popular railroad operations that lie behind Congress's inclusion of that broad preemption provision in the Act. I also want to draw your attention to the submissions in this proceeding of the AAR and the Class 1 carriers Norfolk Southern and CSX, which point out in a number of particulars numerous and significant types of transloading activities which the rail industry provides its customers in a variety of contexts other than C&D. Commodities as varied as set-up automobiles and lumber, aggregates, building materials, grain, corn syrup, coal, chemicals, intermodal equipment, and so on. Transloading of all that's become very common in the industry, and indeed railroads are constantly being pushed by their customers to do more of that and to be more innovative and creative, to be part of the ever more complicated logistics chains that railroads are part of. And the board should be very mindful of this fact if it seeks to craft broad principles or sweeping interpretations, which again I urge you not to do, but if you do that, of what may constitute transloading or a rail facility. And of course, for that reason and for the reasons we've identified in our written comments here, emphasizing the significance of obtaining all relevant facts about a specific facility or activity to which a preemption claim is being made, we urge you to avoid making a decision in this case that goes beyond the scope of the issues relating to New England Transrail's specific proposal. I guess I'd like to end with just sort of a point that's almost become a personal burr for me, and it shows, I think it's an illustration of why it is so important to make sure you've got the facts and got the facts right about these facilities. This harkens back to a case in which I represented the Susquehanna some years ago. It's the Borough of Riverdale case, which you and your staff are familiar with, and which gets cited by many of these parties. It hit me yesterday when I was reviewing the comments here of the Raritan Baykeeper at page 20, when that commenter indicated that Riverdale, he was giving examples of processing facilities, rail processing facilities that were inappropriate. And they said, for example, in the Borough of Riverdale case of the corn processing plant. Well, that's become like an urban legend. There isn't and never has been a corn processing plant in Riverdale. The Susquehanna never served a corn processing plant at Riverdale. That case was settled, so there was never a final decision. But if you actually go back and look in the docket and look at the pleadings, including photographs that we submitted, what that little facility was about was corn syrup. And the Susquehanna had a chance to bring corn syrup to a candy company in New Jersey. But corn syrup is a very thick, viscous commodity. And so what Susquehanna did was, on its right-of-way, it built a little, for want of a better term, a pad, paved area with a scale and some lights and a sidetrack, and it installed some hydrants that were heaters, so that when you can visualize this, a tank truck would come into the facility, the guy would weigh his truck, and then he'd go down next to these little hydrants and plug his hose in, and it heated the hose attached to the rail car, heating up the corn syrup, making it more viscous and therefore more easily transloaded into the truck. And that's particularly important in New Jersey in the wintertime. That was the quote-unquote corn processing plant. That I would submit as a classic, appropriate rail transloading facility. It was integral to the transportation. It was necessary to unload the product. And the community didn't like it because they didn't want to have big lights, and they didn't want to have a truck scale, and they didn't want to have trucks coming in and out. At the end of the day, you concluded there was a preemption there, and as I say, that case was settled, so it never got, the corn processing never made its way, I guess, into the ICC reports is what I'm trying to say, but I would like to use that as an example of how critically important it is that you do get and understand the facts in these particular cases. And I see my red light is on, and I will stop. Thank you.
Thank you, Mr. Motes. We'll now proceed with the final member of this panel, Mr. Frank Damasi, who's been allocated no more than 5 minutes. Mr. Damasi, welcome, and please proceed.
Thank you, Mr. Chairman. I'm here as a citizen advocate for rail freight and freight in particular. I retired from the Defense Contract Management Agency in Boston as a manager and a certified Department of Defense acquisition professional. I've worked for 34 years for the Department of Defense. And in dealing with Department of Defense issues, freight movement, it was a really big issue in my environment. The rapid decline of freight rail capability, performance, and access in the Boston metro region became vividly apparent during my oversight of Department of Defense contracts in my area of responsibility in Massachusetts and New England. Contractors under my unit surveillance were engaged in receiving and shipping millions of dollars of goods and materials. Beginning in the 1990s until my retirement from the Defense Department in 2002, virtually all the freight that had moved on government bills of lading via rail and sea shifted to truck because of a lack of adequate rail and port infrastructure in the region. Based on my professional experience, there is an overwhelming demand for a well-located rail transload facility, such as that proposed by New England Transrail. The site is ideally located close to the core metropolitan area with easy access to two of the region's major interstate highways. Recently, railroads in the Northeast, which owned extensive parcels of land in eastern Massachusetts, especially in the Boston urban area, used for transfer terminals and other support functions, realized skyrocketing real estate values in the Boston metropolitan area. And land use is a big issue in trying to site industrial enterprises and transportation enterprises in our area. Having a lack of capital for maintaining redundant track and facilities, and with declining rail freight demand, railroads in Massachusetts saw greater profits in selling off these parcels for real estate development than continue their use in transportation functions. Now, these sales eventually hindered the railroad's ability to transfer freight between rails and trucks for local deliveries, which furthered the decline in rail freight. And in particular, I'll wander a little bit from my notes, but terminal rail operations and branch line rails operations handle the kind of interface between that last mile and the larger regional and class 1 regional railroads, who don't want to do that switching and high-cost maintenance of rail yards in those facilities. So this kind of an operation really fills a gap that the larger railroads just aren't doing. This trend continues with the current commercial, retail, and residential development of a vital Pan Am rail yard across from downtown Boston and Somerville, abandonment of the Mystic Wharf branch rail connections to the docks and terminals located on the Mystic River, Chelsea Creek, sale of land occupied by the Beacon Park rail yard, CSX owned and leased in Alston to Harvard. The sale of that rail yard was made to Alston to Harvard University, and that will further limit functions of that yard. And there are disruptions of rail connections to Connolly Terminal, which is the port of Boston, because of the Big Dig Highway project. So we've lost our port connections by rail, and we see this kind of a transload facility as replacing some of that lost infrastructure. The Federal Highway Administration projects that if we do not change our transportation system, freight transported by long-haul truck will increase by 63% in the next dozen years over Massachusetts' already congested highway system. I've included some of the some of this data in an appendix which I provided to you earlier. Clearly, the continued use and rehabilitation of existing rail lines and the expansion of rail multimodal transload facilities are needed to sustain the economic viability of Massachusetts as projected increases in demand to move freight are realized. Reliance on trucking to move this increased demand over the existing highway system with our constrained ability to add to its capacity is not a viable strategy. We have about a $19 billion shortfall over the next 20 years just maintaining the existing infrastructure in Massachusetts, and we have no revenue stream as of yet to support that. So the more we beat up our roads and highways, the more we're going to be in trouble in logistics and in supply chain management. NET's proposed enterprise is the type of facility that will be required to revitalize rail freight transportation in the Boston metro area. This facility will handle a wide range of inbound and outbound products and materials, from biofuels with its new and rapidly growing transportation infrastructure demands to more traditional commodities like corn syrup, lumber, steel, paper, and other bulk commodities inbound. Since eastern Massachusetts' major export is waste products, waste will be a major component of the terminal's outbound freight. Rail freight presents an overwhelming pricing advantage over trucking because of rail's inherent transportation efficiencies, and diversion of freight from truck to rail will save Massachusetts and the municipalities tens of millions of dollars per year in waste disposal costs. In conclusion, to embrace an economically driven, multimodal freight transportation policy in Massachusetts, make better use of and sustain available freight rail capacity, improve the efficiency of movement of freight in general, deal with the rising and forecast unmet demands of moving greater amounts of freight in the near future, including enhancement of national security and emergency response preparedness, Surface Transportation Board should expeditiously grant NET's petition. And thank you very much, sir, for being able to testify. It's kind of a thrill for a citizen to have this kind of access, and I truly appreciate it. Thank you.
Thank you, Mr. Tomasi. We'll proceed with questions. I'll begin. I'll start with you, Mr. Tomasi. If I understood your statement correct, you are appearing here as an individual private citizen. You are not. You have no financial interest in this project.
No, sir. You
don't own any real estate adjacent to it that might somehow benefit from it, or
no, sir.
Not being paid to be here by anybody.
No, sir.
And I think we'll hear from other citizens later today that in similar statuses. And I commend all of you for taking time out at your own expense to speak out on an important issue on all sides of this issue. Now, granted, we didn't give you a lot of time today, so I want to give you a little bit of time during the questions.
Appreciate that.
What, and I think we're all, I know I certainly am sympathetic to what it must be like for folks in the community there around this former Olin Superfund site, Olin chemical site that's now a Superfund site. They've put up with a lot. They've presumably, they've been put through a lot of fear and heartache and perhaps worse. And now comes development plans of probably of a wide variety, including New England Transrails. Do you have any suggestions for this board about how reasonable health, safety, and environmental concerns might be addressed if we were to eventually allow an operation such as this transload operation go forward?
Well, my expertise, and it's learned in the past 5 years of retirement by reading issues, taking part in public forums, is more in the needs of freight industry in particular, and we're facing a supply chain management issue in Massachusetts because of the high cost of goods. But I also served on a local planning board for my town, and I realized that with any kind of development, we look for mitigation to the abutters. So in this case, it's more than just mitigation from noise and other issues. I realize how the importance of environmental issues, and especially this community, which has borne a tremendous cost to that issue. But when I look at the proposal from just a transportation point of view, there seems to be willingness to comply with local requirements and to provide mitigation in terms of a covered building, very responsible engineering in developing of the site, the way the tracks are laid out. I'm sure there's going to be some consideration for the current issues that are under the ground and whatever. The problem is that there are so few industrial sites available that are economically viable to develop for transload facilities or even passenger facilities, layover facilities. They're terribly things to cite. So when the community is faced with this kind of burden, that's a regional benefit, but a definite local burden, we expect that mitigation would be provided. That might be in extraordinary oversight by proper people that are in charge of those issues, and recurring oversight, reasonable barriers, visual barriers, and whatever it takes to mitigate sound, noise, dust, those kinds of issues. So, I think it's a joint responsibility. I also understand that local regulators tend to overregulate, and in many cases, we have trouble bringing new industry in or developers in because of the cost of permitting and those kinds of issues. And we're in really jeopardy of losing our jobs in the state. We're in jeopardy of having an antiquated infrastructure system while all this other high tech goes on. So there's kind of no middle to this thing, and that's where my advocacy lies. So I don't know if I'm answering your question, but that's the best I think I can do on that.
Thank you. Thank you, Mr. DeMasi. We'll hear from many folks who might claim some degree of greater expertise than you might claim in some of these matters, but I think it's important to hear from folks who just bring good common sense sometimes, and you sound like you might be bringing some of that to us today. Just out of curiosity, if this proposed operation was interested in bringing in municipal solid waste by truck, dumping it onto a cement floor, scooping it up or bundling it up and putting it into a rail car, would you define that as integrally related to transportation?
I believe it is. Now, I happen to live in a knockdown neighborhood in Wellesley. There were like 6 knockdowns on my street alone. Now, the way you knock down a house is you mush it into the foundation, and then you load it into a container, and then it gets trucked out of your neighborhood. So this kind of loading, unloading, reloading happens in our neighborhoods. Now, I mean, what do you do with this stuff? How do you handle it? So the way it was explained to me, and I queried, the Transrail folks, because I don't want to do something that's stupid. But it seems to me that what they're explaining is a way of reasonably loading a rail car by handling the material, separating some of it out before it's put in the rail car in a certain sequence. And that kind of is a logical way to do loading of something that we need to get rid of. And the further away that site is, the more trucking you have getting there. So it's really good to have some locally, dispersed transload facilities to do that kind of operation.
Thank you. Mr. Motes, you're a veteran railroad regulatory practitioner. You seem to be well versed in much of the case law and some of the precedent and some of the statutes in this regard. Let me ask you, if I could, first of all, you talked, of course, about the case of most interest to your client, which makes sense. It's a case not before us today directly. I personally don't propose to interfere with the pending decision-making of the Third Circuit or any Circuit Court of Appeals. We look forward to seeing what they have to say to help shed light on this matter. But there are perhaps some important distinctions, if I heard your statement correctly, between the facts in your client's case in New Jersey and the facts here. You have been recognized by a U.S. federal district judge as an established rail carrier, if I heard you correctly, and not a new entrant.
And by you.
Right.
Yes.
Minor detail.
Right.
And by this body, probably before my personal tenure. But should that matter? In other words, let's say we wrestle with this case, do the best we can, arrive at some what we believe some reasonable outcome to what is a new entrant case. This is related to, we're having a jurisdictional hearing today related to eventually making a licensing type decision for someone to become a recognized rail operator. Assume this case eventually is behind us one way or another, and your client or another established railroad decides to add a line of rail operations, such as handling municipal solid waste, receiving it, dumping on a cement floor, picking it up and putting it into rail cars and taking it away. Or perhaps routing, for some reason, chlorine tanker cars, which are important, of course, for drinking water purposes for a lot of municipalities. Maybe parking those chlorine tanker cars for a period of time on the rail property. Nuclear waste occasionally passes along the railroads. And things that are probably maybe less controversial, but could be of serious concern to locals, whether they be livestock, thousands of automobiles getting ready to come and go from a port in a parking lot illuminated by bright lights for security reasons, etc. What in your view, what is this board's role? What's our jurisdiction in a situation, any of the situations I just described, assuming it is an established rail carrier that's just deciding to add another arguably traditional type of rail operation to their business?
It's a complicated question, Mr. Chairman, because you put a lot of different scenarios in there. I'll do my best to respond. Yes, the first point is, yes, the Susquehanna obviously is and has a long history of being an operating freight railroad, and the facilities that have been the subject of the litigation in New Jersey are facilities that are sited on its existing right-of-way. There are, as I tried to show in those photographs, there are side tracks that come off of the New York Susquehanna main into these facilities, and the facilities are served by the Susquehanna switch crews. Locomotives come in and place those cars and pull them out. Those facilities are on property owned by the railroad, and the loaders at the facilities, the people doing the loading of those rail cars, are employees of a wholly owned Susquehanna subsidiary. Judge Hayden found all this to be the case. It is a railroad operation. If the Susquehanna or some other railroad were to decide that it wanted to build a new line, as you posit, or a new track, again, I guess it would depend on whether we're talking about something that would require a construction application approval from this board, or if it's a traditional exempt spur siding, you wouldn't have jurisdiction over it. You've noted that a number of times. The railroad could build it. Does the railroad build it in blissfully in lack of care or concern or awareness of safety and environmental considerations? Obviously not. And railroads have, as you know, very sophisticated engineering departments and operating departments. They have environmental people that deal with that. If it's a construction application or any kind of an action that requires them to come here for authority, you obviously have the ability to attach environmental or other type conditions to your approval if you give it, to your authorization. But even when they build so-called exempt sidetracks and spurs, the railroads are very careful to comply with appropriate local safety, public health, environmental consideration. The problem we had, candidly, in this litigation, as I try to point out, I said it a couple of times, is the state of New Jersey had an agenda, or more specifically, the New Jersey Department of Environmental Protection and certain people we believe in their Attorney General's office had an agenda, and they acted on that agenda. The governor was behind them. The agenda was to shut these facilities down. They don't want them. They don't like them. New Jersey has a very comprehensive and very active and vigorous environmental enforcement department. With the Deputy Attorney General in charge of that case is here today, and they are well-staffed and well able to represent their interests vigorously and aggressively, and they have in this case. I would submit, and I have in open court said this, and I've told Mr. Auerbacher here this, I think they chose the wrong target. We're very sympathetic with the so-called high-tech problem. And again, I'm saying nothing about New England Transrail. I really don't know enough about their operation. It sounds to me like they have made a real effort to deal with the kinds of considerations that have arisen in high-tech and similar cases. But, again, we believe, and I think the AAR and Class 1s that filed are trying to tell you that there is a problem, and the problem is with the abuse of your exemption procedures for people trying to be deemed to be rail carriers so they can then climb up the ladder and say, we're not subject to all these local laws and regulations. I think the real problem here is the oversight of the exemption process, and heightening the scrutiny there, I think, will go a long way towards resolving those kinds of rogue operators, as they've been called, problems. That wasn't the Susquehanna's problem. The Susquehanna had a problem with the state's agenda, and as I say, the federal court in Newark concluded at the end of the day that the state had overreached and that those regulations had one purpose and one purpose only, and that was to harass the hell out of the railroads and to interfere with rail operations. States can't do that. That's what the preemption provision is all about. Now, we'll see if the Third Circuit agrees. I'm guardedly optimistic that it will. We shall see. One other thing about New Jersey that I ought to say, and it's really remarkable in a lot of ways, even the state government, I think, was not wholly of one mind about these facilities, by which I mean the New Jersey Department of Transportation on 2 different occasions afforded cash grants to the Susquehanna to help finance and build the facilities that the Department of Environmental Protection is trying to shut down. But well over $1 million in New Jersey taxpayer money went into those facilities. So there are clearly a lot of agendas here, a lot of enforcement agendas. I respect very much Mr. Auerbacher and his colleagues and the concerns they're trying to deal with. We just really think they kind of got it wrong. The Susquehanna has worked very hard to try to do what we believe to be reasonably necessary, and of course there's disagreement about what reasonably necessary is. That's why we go to court. But we have not ignored their concerns. You saw those facilities. They are not open dumps anymore. If they were, the facilities are enclosed. They have misting systems. They have water runoff systems. They have lights. They have guards. All that.
Let me interrupt you. Sorry to do that, but I'm interested in hearing certainly your knowledge of the law and the regs, and probably I'm less interested, just with all due respect, in hearing about the Susquehanna case. It's just not before us right now. You're perfectly in your rights to try to educate us on it. You have, but let me try to just ask you another question too. If I heard you correctly in your answer just now, if it was on, let's say an existing rail carrier has existing siding that would be exempt, if I understand you correctly, from regulation, and a railroad decided to, for the first time, bring in an existing long-standing railroad, bring in chlorine tanker cars or cars full of nuclear waste that were otherwise consistent with recent traditional railroad operating practices around the country, park them for a period of time, move them in commerce, that this board would have a lot of jurisdiction to do something about that? Not much, none?
First of all, we don't want that stuff. And now I'm not speaking for the Susquehanna because they don't handle nuclear waste, or I'm not sure about chlorine. I think you well know that this is a very thorny issue for the national railroad industry right now, and we're not, I don't know of any railroad going out and trying to garner chlorine business or nuclear waste business, but we have to handle it. We have a common carrier obligation.
Exactly, I was going to say, you have a common carrier obligation.
So we have it. We have it. We have to put it somewhere. It goes into a yard. In fact, as I know you and your staff know, TSA and the Department of Homeland Security have new regulations that have been proposed, and I don't believe have quite been adopted yet, but would specify with a good deal more detail than heretofore how that kind of traffic has to be handled, how it has to be watched, even guarded under the proposed regulations in rail facilities. Do you have jurisdiction over that? I don't believe so. I think that, you know, while we all understand the great concern about chlorine and nuclear waste and the like, in the context in which you're asking the question of me, it's rail traffic. It's traffic moving on the interstate rail system.
Thank you. I think you've just answered my question. Lastly, there is some interest in this case among some stakeholders. In fact, I think I heard it loud and clear from the distinguished senator this morning that we use this opportunity with this New England Transrail case to bring what I would view as a line of cases in a broad area of controversy flowing in multiple states, bring some closure to those controversies once and for all. And we're looking at that, to be honest. But I can say personally I'm struggling with how we do that. In other words, just as soon as we think we've gotten MSW rail regulation just right, updated, modernized, what's the next case? In other words, what's your read of the federal preemption grant, and do you see a real possibility that this board could actually bring the broad area of dispute to closure with this case, and if so, how, frankly? And if you don't want to answer that question, you don't need to. But
no, I'm not afraid to try to answer it. I think the answer is no, you probably can't. And I also further suggest that you probably shouldn't try to, in the very broadest sense. I say that with all due respect. Congress wrote 10501B. Congress, as the senator suggested, could modify 10501B. I'm not advocating that, but I mean, he's well aware of that, and he has co-sponsors to his legislation, and that's Congress's bailiwick. But for the board to essentially try to circumscribe or in some manner interpret 10501B in a way that you, obviously through the best of intentions, where you were trying to deal with the kinds of situations that I'm suggesting seem to be coming primarily out of your exemption process, I think would not be appropriate. And at the end of the day, I don't think it would necessarily withstand judicial review if someone were to challenge it. But that's my personal take.
thank you. And last question for you, Mr. Mose. In your view, if in fact New England Transrail actually operates as it proposes to, interconnects a rail line into other rail lines that serve, that run through and are part of interstate commerce, do you think we have as a board much flexibility to say, now, boy, this case would be a lot easier if we just say you're not a railroad? My read of the statute is that rail carrier means a person providing common carrier railroad transportation for compensation, and it includes a switch, spur, track, terminal facility, and a freight depot, yard, ground use are necessary for transportation. And transportation includes a locomotive, car, vehicle, vessel, warehouse, facility. I'm skipping a few words here. Equipment of any kind related to the movement of passengers or property by rail, regardless of ownership, etc. Regardless of ownership, it doesn't say you have to be a known and proven entity. And services related to that movement including receipt, delivery, elevation, transfer, in transit, refrigeration, icing, ventilation, storage, handling, and interchange of passengers and property. How much discretion do you think we have to just make this case in the eyes of some a little easier and quicker to dispense with by saying, you're not a railroad NET? I'll ask others this question too.
again, without in any manner commenting on what I am not in a position to comment on, which is the indicia that NET may have brought forward to suggest they meet the standards to qualify for your exemption and to be a rail carrier. If you were to conclude, based on your traditional standards and your traditional analysis, that they're not, then I think that would solve this case. It isn't going to solve the broader problem. As I suggested to you, and it may, I understand, Mr. Chairman, you're searching for the possibility of a broad resolution, a way to break the Gordian knot here. Gordon's knot. I don't think that you can do that. That's why I said during my opening remarks that it's critical for you to have the specific correct facts and circumstances about each one of these proposals, because that's the way your case law turns. It is very fact-specific, very searching inquiry as to whether the indicia and standards that have been identified in a long line of cases are met in a particular case. Only other thing about your reading of the statute that I would like to say one thing about, it's talking about what a common carrier really is, a common carrier facility. That became an issue in the New Jersey litigation. It could become an issue here. I would only remind the board that there is another rich history of learning about what a common carrier facility is, and the fact, for example, that a facility may be used by only one customer, Ford Motor Company, Cargill, a waste company, does not render it not a common carrier facility. And there's a long line of cases that make that very clear. I think we have to be a little bit cautious about the terminology and trying to reinterpret some of the terminology with all the learning that the ICC and the board have on some of these concepts.
Thank you. One last follow-up to that line. Are you saying that there is anything in statute that gives us guidance or in case law that if a railroad is kind of on the short side of things as far as the track not being super long, or a railroad not being a household name, or perhaps a new entrant, that we ought to use those factors to knock them out and say they're not proposing to be a railroad?
No, not at all. I didn't mean to suggest that. I mean, I suppose at one point the Union Pacific wasn't a household name, so everybody starts somewhere.
Thank you. Great. I've got plenty of questions for Mr. Van Tine, but I want to defer to my colleagues, give them a chance to ask some questions. Just from a procedural point of view, if I could ask staff, will we have an opportunity to question Mr. Van Tine after his closing? Okay. This is my first hearing of this nature, so I just want to make sure I don't miss an opportunity, Mr. Van Tine. So I'm sure we'll have another round of this panel, so bear with us, but we'll now proceed with this first round, and I'd like to turn to the Vice Chairman, Mr. Buttry.
Thank you, Mr. Chairman. Mr. Votes, I had a few thoughts while you were testifying about the Jackson case and the facts of the case. Case turns on the law and the facts. We have to pay attention to the facts. So I was wondering if you said you had been out to some of these facilities and you're very well aware of what goes on there. I gather from your testimony so far is that all of these facilities, let's say the 5 main facilities, there's a 6th that's sort of different, but certainly the 5 that we're talking about, focusing on. Is it correct to assume that at those facilities, basically the only thing that happens there is that the construction debris or whatever is brought in, nowadays it's put inside of an enclosure of some kind, which is a huge improvement, obviously. And then it is loaded without doing anything else to this material. It is loaded into a rail car that is also apparently inside the building and netted and pulled away. Does that describe adequately what happens inside those buildings?
Yes, with one exception that I'm sure the state's representative will be quick to talk about. And I think it is discussed in the NET proposal as well. And you ask, or you put in the qualifier, nothing else is done to it before it's put in the rail car. Yes, something is done to it. There is a man will walk around, and when he sees so-called non-compliant material, piece of copper, a washing machine, you'd be amazed at some of the, I've been to the facilities, you're right, it's amazing what you find getting dumped out of these trucks. Mm-hmm. Things that would either damage the rail car or would be rejected by the landfill because it's something that's not compliant, that is pulled out, put aside, now put in a dumpster. You know, again, in our case, the state took the position that we were engaged in recycling. Well, what would the preference be? To dump it over off the property over here? I mean, you know, and Susquehanna is not making money from that. You know, they get rid of the stuff when there's a dumpster load. They come and have it removed and emptied and the like. That's the only change that I would suggest to the way you describe the process. Again, Mr. Vice Chairman, this is not a terribly sophisticated operation. I mean, it is.
You're not changing the size and weight or the nature, the character of the debris.
At these
You're
North
not
Bergen,
changing its chemical composition.
No.
You're not changing the liquid into a solid or a solid into a liquid.
no, and also I should say very clearly, this Susquehanna does not handle municipal solid waste. We keep throwing those terms around. They're very different concepts, and we understand that. We're talking about construction and demolition debris, not NMSW, and that is a different game.
Mhm.
But no, you're right. You've described it correctly.
Okay. Can I go to anybody on the panel now? Okay. Mr. Van Tine, you've dropped off to us today a surprise document. You know, on TV they just throw these out. But anyway, I think the ruling is that even though it is a surprise document and a late file document, apparently, the board's rules about accepting these documents are very liberal, fairly liberal, and my understanding is it's going to be accepted and put in the docket. If you could, for me, could you just tell me what this is all about and what's in this document, since we don't know, we haven't had time to read it, we didn't see it before the hearing, we have no idea what it says, but you've given it to us, and apparently you want us to consider it, and so could you summarize for me what's in this document?
Yes, sir. I passed up two documents, and I presume you're referring to the statement of Mr. Jones.
The most recent one.
Yes, sir.
The first instance, correct me if my assumption is correct, you have basically done everything you possibly can to comply with New Jersey regulations and laws, except technically submit yourself to their jurisdiction.
Massachusetts, Mr. Vice
Excuse me,
Chairman.
I'm sorry. I was thinking
We're
about
talking about a
Lautenberg.
different state.
Senator Lautenberg is still very uppermost in my mind here. Massachusetts, I'm sorry. You have done everything. It seems to me, if I'm correct, and correct me if I'm incorrect, that you have done everything that you could possibly do to comply with whatever it is that the state of Massachusetts wants you to do, except technically submit yourself to their jurisdiction. Is that accurate? And does this document that you filed today bear on that issue in any way, shape, or form?
I think that's a fair statement, but again, in fairness, I want to point out that the discussions that we had with the Massachusetts authorities began, but didn't go real far. I think that our position is that, going back to my comment in my opening, that I don't think that there is truly a regulatory gap in the sense of a void. There is a body of law that's the board and the courts have developed to determine what kinds of state activities would impose an unreasonable burden on rail transportation. That's the test, whether they would impose an unreasonable burden. And so this is not an all or nothing proposition in terms of preemption. There are some things that clearly are preempted. There are some things that clearly are not, according to the board's past decisions, that are categorically are preempted, some things that aren't. But then there are a lot of things in the middle that you sort of have to work out and see what the regulation says. And I think Mr. Moats referred to one of those things in New Jersey that, as I read the district court decision in Jackson, it was not so much the actual language of the regulation, but the way it was being applied and the effect that the regulations might have on the railroad. In our case, what we have done so far is read all the Massachusetts regulations that we think might be applicable to this operation and propose that we comply with all of them except for the ones that the board has held or categorically preempted in the past, like site assignment and preclearance regulations. And so, you know, to your point, have we done all that we could possibly do? I think that we would have we would envision, if this process were to proceed with Massachusetts, sitting down with the Massachusetts authorities from the Attorney General's office and the Department of Environmental Protection and going through the list. Here's our list. Here's what we think applies. Do you think this is the right list? Do you have anything you want to add to the list? Is there anything that doesn't apply? And work through that whole list and make sure that we're in agreement. Since the only things we know about that we're not going to comply with are the things that you've already categorically preempted, I think that we're in pretty good shape. And there was one other thing, as I recall, and I may be wrong about this, but I believe that they may have some special noise requirements that apply to railroads, and we believe there are federal noise requirements that apply to railroads, and we would substitute those. But everything else regarding health and safety, we have conceptually agreed to comply with. Yes, sir. And we would do that in writing. I understand there's a practical issue about enforcement and how do you coordinate state inspection, enforcement, compliance efforts with federal jurisdiction. And I understand the position of some of the parties who have filed briefs on Monday, saying that that's just too hard and the board would be dragged into thousands of proceedings all over the country. My own opinion is that that's not correct, that, as I said, this kind of situation conceptually has been going on for many, many years, and in many situations, local communities and railroads have found ways to coexist through working out agreements, and the federal authorities do not get dragged into every dispute. And the test, again, if everybody knows what the law is that if it unreasonably burdens rail transportation, then it's preempted. If everybody knows that, then things, conceptually, things that the state wants to do in the way of enforcement or inspection that don't, quote, unreasonably burden rail transportation, our clients certainly would have no problem with and would not argue about. The issue would arise only when you get into the situation, as I understand from the Jackson decision that Mr. Mote's client found themselves in, where, according to the decision, the state was attempting to take action through their health and safety regulations that would unreasonably burden rail transportation. So, short answer is we still have a ways to go with Massachusetts, but I'm reasonably confident we could get to the point of a signed agreement fairly quickly if they were willing to sit down and talk to us.
I sort of got you off the original question. I appreciate very much your response and your answer. But can we go back to the document itself? And
Yes,
is
sir.
there anything different in the document submitted to us today and what
Yes,
you
sir.
just said?
First of all,
Can you elaborate on that?
I apologize for the so-called surprise. It was late. But the problem that we saw in reading, I read all the materials that were filed on Monday by all the parties, and as I mentioned in my opening, we see this sort of passing in the night where we say something, the other side says something that doesn't indicate that they've even read what we filed. And Mr. Jones's supplemental verified statement is intended to address some of the key points that we saw in the filings on Monday. One of which is this issue of whether we are willing to try and work this out with the Commonwealth of Massachusetts. That's point number one, and the answer is yes, absolutely we are. Another is, do we qualify as a rail carrier? That hasn't gotten a lot of attention in the past pleadings, but that's an issue of interest that we saw in the briefing on Monday. And we wanted to have in the record, in a verified statement, the facts that the board has considered in past cases about the indicia of who is a rail carrier. Mr. Motes alluded to some of those, and that is part two of what's in Mr. Jones' statement, the facts of what New England Transrail's operation is going to be. Things like we're going to own the land, we're going to own the rail cars or lease them, we're going to own an engine or lease it, we're going to have our own employees, we're not contracting out, the employees are going to be eligible to be members of the applicable rail unions, we're going to pay into the Federal Railroad Retirement System, we're going to comply with all the safety regulations of the Federal Railroad Administration. All the indicia of being a rail carrier that you've heard in the past, or that the board has indicated make people qualify as rail carriers, we're going to do. The chairman alluded to the statutory test of common carrier for compensation. Absolutely. The list of shippers that have approached the principals in this project has grown over the time since this application has been pending. And I guess that's the good thing about having controversial projects. A lot of people hear about it, but a lot of people would like to use this facility to ship a variety of commodities in and out of this particular area. So that's part two. Part three is we were sort of challenged in the Solid Waste Management Association pleading to answer some questions. And I presume the thought was that we were trying to pull a fast one or avoid giving this board the truth somehow. So just to make the record absolutely clear, we didn't want to let those questions hang out there with no answers and leave the implication that we were afraid of those questions. And that was the third purpose of filing the verified statement, would answer the questions. The questions are stated in the exhibit, and we think they're clearly and directly answered. And if there's any further question about the answers, we're happy to. We brought Mr. Jones here. He can talk about those things, but I think they're very simply, directly answered. No attempt to evade anything, and we tried to do it to minimize any ambiguity in the wording that's used. So those were the purposes. And Mr. Vice Chairman, I just want to repeat again that I understand that this was late. I appreciate your suggestion that the board will accept it for what it's worth. And I want to reiterate that we did make a real effort in the hour before the hearing commenced to reach as many of the participants in the proceeding as possible and actually hand them a copy of it so they would have an opportunity to read it before they take their positions here and speak.
Mr. Chairman, I may have other questions later. I want to reserve the right to ask those questions later, but in deference to Mr. Mulvey here, our fellow commissioner, I've taken up a lot of time here, and I want to defer to him now.
Thank you. I'll just note that a number of things have been shown, illustrated, photos, et cetera, today for the first time. But I think that's why we're having a hearing, and as long as all the parties get it, we don't plan to make a decision today. It's a priority case. We plan to expedite it, but I think anything that comes in appropriately, anything that comes in appropriately today that's relevant to the case, we are happy to receive. With that, Commissioner Mulvey.
We'll be able to, I'll ask some questions and then we'll go through another round of questions. Okay, fine. But to begin with, you mentioned that you felt that there's no regulatory gap. But in a sense, there's certain operations, certain parts of railroads, such as improvements in a railroad processing facility that already exists, that we would not regulate. For example, the Susquehanna Railroad in New Jersey, if there was to make an improvement in some of its yards, et cetera, we would not regulate that, and yet any local rules and regulations governing that yard would be preempted. Under 10906, we don't have the jurisdiction to regulate the construction operation of a spur, industrial, or sidetrack. This came up in the Staten Island case where at the Fresh Kills landfill, a track was extended into that area in order to bring out solid waste. New York and New Jersey DEPs both wanted to regulate that and impose environmental rules. We said that we preempted, but then we said we have no jurisdiction over sidetracks. So we preempted the state and did not do anything ourselves. Would you consider that to be a regulatory? I can think of another example in Minnesota also, where there was a yard where they were storing railroad was storing containers, and again, there was no way for the community to regulate what was going on in that yard. And on the other hand, we did not have any jurisdiction. Would you still say there's no regulatory gap given those examples?
Well, I'd say first that that's not our situation. That we're in a little bit different position.
But you made a broader statement. That
yes, sir, and I probably overstated the sort of a generalization about the law there. I don't, first of all, I don't pretend to be an expert in railroad law, and I certainly am reluctant to offer opinions about railroad law when you've got some experts in that subject sitting directly behind you. But I think that in the beginning, when the preemption statute was drafted and when the other aspects of rail regulation came into being, there certainly was a regulatory gap, and it was a void. What I was trying to suggest is that over the many years that those statutes have been in existence, the rail carriers and communities and the ICC and now this board have tried to fill that gap. And so my only thought was that there is not a total void. And that's an important thought, I would suggest to you, Commissioner Mulvey, because many of the pleadings that were filed on Monday suggest that we are in the sham carrier category, where we're trying, the only purpose of coming before this board is to avoid all state and local regulation, and those pleadings have suggested to you that there is still a total void. And my point is that only that there is not a total void. There may be areas that still need to be addressed, and the area that you've mentioned may well be one of them. But I would suggest that in the area the space that we occupy or would like to occupy, again, I'm not a railroad law expert, but I have read Effingham and I have read all the subsequent decisions, and I don't remember in any of those decisions a factor that depends on how long your track is. What I remember is the intended use of the facility and some of the indicia of being a rail carrier that I've mentioned earlier. So I think that in the space that we would like to occupy as a rail carrier, I think on the legal issues in this case, there have been a number of decisions directly on point, and Mr. Mote's decision is the most recent, I suppose, but there have been several other decisions about waste that touch on various aspects of trying to fill the gap. But then there is a long history of other activities that rail carriers have provided historically, and how they relate to rail transportation. And I suppose that what the board has tried to develop over the years is that, because the statutory term says that you have exclusive jurisdiction over activities related to rail transportation. And my assumption from reading the cases is that what you've tried to do over the years is give some content to how closely related the activities have to be. And I presume that, at some point in the chain of activities that happens between manufacturing a product or growing some agricultural commodity and getting it to the end destination, there are a lot of steps, and some are more closely related to rail transportation than others. And my perception is that what the board has tried to do over the years is try and work out some guidelines about where on that spectrum of relationship to rail transportation you have to be to qualify. And what I'm trying to suggest about our facility is that we're right at that point where we are the missing link, the next step that enables the rail transportation to occur.
It's to suggest that we narrow this hearing and try and focus on the NET proposal, and I'd like to do that and ask some questions directly about the NET proposal. First of all, how was this project first conceived, and at what point in the development of this project was the idea for NET to become a railroad, and who proposed it? What specific factors did the NET weigh in deciding how to structure these operations and become a railroad? What led to that? The concern, as you know, is that it was done in order to evade the, so
Yes, sir. And I'm probably not the best person to address that question, and in fact, I'm sure I'm not, because my association with the project doesn't go back that far. I know that there was a considerable, I'll tell you what I do know, that there was a considerable amount of research done before any formal proposal was made, that it was determined that this particular site was an attractive location for a rail facility because of the lack of rail facilities in the area that Mr. DeMasi has mentioned, that within the Commonwealth of Massachusetts, again, as Mr. DeMasi mentioned, there has been a steady decline in the available rail facilities, in particular transloading facilities, and that there has been a corresponding increase in truck traffic. All of that was part of the review work that was done. There was discussion with railroads, there was discussion with potential shippers, and of all kinds of commodities, and there was, of course, the knowledge that there was a possibility to ship C&D waste and MSW, because that is something that has been going on now for a number of years, and it is well known that Mr. Moat's client derives a good deal of revenue from that. So that has always been part of the concept, but it has also always been part of the concept, as I understand it, that the facility would be a rail carrier and would be a common carrier for compensation, and would transport both in and out of the facility a wide variety of commodities, limited only by the number of people, the kinds of people that want to ship things. And with one other exception, I think there has been a decision made, at least preliminarily, that we're not going to deal with hazmat because that gets you into a whole different category. As far as I'm aware, the concept has always been that the facility would serve as a common carrier because there is a need for such a facility in the area. And I don't have a lot of experience with the Surface Transportation Board and rail carriers, but from what experience I have had, I know that if I had a choice between being a shipper and a rail carrier, I think I'd rather be a rail carrier in terms of just the operation of this kind of a facility, and not for the purpose of evading state or local regulation, but just because of the way the regulatory system operates with respect to rail carriers in all other aspects of the system.
well, you say in your opening statement that the Boston and Maine Railroad, another railroad that serves Massachusetts, was reluctant to develop the Olin site itself in this type of project. And why was that? Why were they reluctant? And what is the New England Transrail's relationship with the Boston and Maine and its family of companies?
Well, again, I'm not the best person to address that question, but I'll tell you my understanding that I don't know, first of all, why they were reluctant to develop. I presume that it was economic reasons, that they did not want to invest the money, or that they did not want to get involved in what at the time was not a Superfund site, but was clearly a troubled piece of property that and did not want to deal with the community issues that would be involved. I don't know exactly. As I understand it, the relationship at present is that there have been discussions with the railroad, and that the discussions have reached a state where there is some understanding about an agreement that would be reached if the board grants approval. Obviously, I can't hold up today a signed agreement with the railroad because the railroad doesn't have anybody really to agree with. But we have, the principals have had discussions with the railroad, and if the board grants approval for New England Transrail to operate as a common carrier, as a rail carrier, we are confident that an agreement will be forthcoming, a written agreement will be forthcoming. And if there's any concern about that on the board's part, I think the simple answer is that if the board were to grant approval, just condition the approval on the production of a written agreement.
You mentioned other shippers. Would these other shippers also be delivering their product to the Transrail facility, or would they be other places, other online operations?
Well, my understanding is limited to the facility. I don't know about other online operations, and I'm not sure I know what that means exactly. But
in other words, another factory?
Oh, no, sir. Not as far as I know. I mean, as far as I know, we're dealing with the operation that will take place within the boundaries that are shown on the drawing that has been filed as an exhibit in this case.
Any of these other shipments, would any of them be considered not waste of one sort or another?
Oh.
I saw vegetable oils, for example, but
Yes,
those
sir.
could be coming from restaurants and things, and they could be used vegetable oils. Would these be products other than things that would be considered waste in one form or another?
Absolutely, absolutely. And that's, again, been an evolving process over the course of this proceeding. I think that the original concept always has been that there would be other commodities, and over the course of the proceeding, a wide variety of contacts have been made, and a wide variety of shippers want to ship things in and out of this particular location. The examples that Mr. Jones has talked about in his previous, he's been involved directly with the potential shippers, and Mr. Klempner has too. And the examples that we've given are for instance, shipments of wood chips and salt and most recently potentially biofuels or ethanol into the area, shipments out of a wide variety of things that are definitely not waste products. They're products that would be sold by whoever is having them shipped. They would be received or sent out, and then when they reach their ultimate destination, to be sold.
Could you please describe the nature of Mr. Klempner's and Mr. Jones' involvement with the high-tech project? Were they investors in that project, or were they principals?
That's a subject on which I have no knowledge beyond what's in the brief that we filed on Monday, where we, I think, pointed out that Mr. Klempner had been involved in the high-tech project. And I think that's a, I don't know how the board views that past association, but I think it certainly is some evidence that he knows something about this subject. And I think that the way that this project has developed certainly indicates that there have been lessons learned from that experience. And I think that it would, I hope that the board would not disregard the facts of this particular project. And I think that that project was one set of facts and one factual situation. There were various reasons why the board decided that preemption did not apply in that case. But not to comment adversely on Mr. Moat's client's project, but in that case, it's pretty clear that the facility was operated by a rail carrier, not by a contractor, and there wasn't any sham transaction going on. It was operated by a rail carrier. Some things that probably shouldn't have happened, and as Mr. Moats points out, they've been cleaned up, and preemption clearly does apply. So I think it would be a mistake for the board to generalize, and this goes back to one of the questions the chairman asked Mr. Moats. I think it would be a mistake for the board to generalize about what kinds of transactions or fact situations are good or bad, and I think that it really does require a case-by-case analysis.
Thank you. I have more questions, but I'll throw it back to you, Mr. Chair.
Thank you, Commissioner Mulvey. I was just taking another look at the submission for the record in this case from the Norfolk Southern Railroad. They chose not to appear in person, but they did submit a statement for the record. It talks about the railroad industry's general concerns in this matter. My understanding is that they don't take a position on what this board should do vis-a-vis the NET application per se, but they are concerned about any broad conclusion that we might reach that could then be applied to other traditional areas of what they view as railroad operations. They talk about that it's pretty common in the railroad industry for rail facilities to transload coal. I'm reading from page 5 of their statement. Chemicals, intermodal containers and trailers, automobiles, grain, lumber, and numerous other commodities. Each of these facilities is unique and is necessarily responsive to the commodity being transloaded, the particular requirements of the location and the needs of the customers. Taking place at these facilities is a myriad of associated and ancillary processes that, when examined in isolation, may appear not to be transportation, but that are reasonable or necessary when examined in the entirety of the transloading and transportation effort. They then go on in a footnote to describe an example. At intermodal facilities, truck chassis must be inspected and occasionally spot repairs conducted prior to release, processes that may not seem immediately to be rail transportation, but which are absolutely necessary to the rail transload function because the chassis should not leave the intermodal facility in an unsafe condition. These same processes are as necessary to a ship-to-truck or truck-to-ship transload as it is to a truck-to-rail or rail-to-truck transload. Later, they talk about automotive facilities on page, make sure I'm reading, actually I'm reading now from the CSX Railroad submission. Page 4 references automotive unloading facilities where vehicles are inspected and prepped. Certain equipment, e.g. tires or batteries, may be installed or replaced, and minor repairs may be conducted. On and on, I won't read the whole thing, but clearly the reason I point those out is in a normal non-railroad operation, all these are types of business, fueling yards. Most rail yards have fuel farms to fuel their locomotives. Automotive repair facilities, perhaps. Typically, if you just plop something like that down in a neighborhood, and it's not a rail operation, it's going to be regulated, of course, by state and local authorities. And so that brings us here at the NET application. One of my concerns is that in finding the right conclusion or outcome to this case, we not do irreparable harm to interstate commerce in this country and to other seemingly more routine, more innocuous, less controversial today, perhaps, but in a certain neighborhood at a certain time, perhaps no less controversial. And so help me if you could, Mr. Van Tine. Your client proposes, amongst other things, to undertake activities, if I read the record correctly, that would include, with regard to MSW and C&D material, baling, storing, crushing, sorting, grinding, perhaps cutting into smaller sizes. Why should we interpret those activities as integrally related to transportation?
Let me say first, Mr. Chairman, that the comments at the beginning of your question about the Norfolk Southern filing and the wide variety of activities that occur in rail operations today is a good example of how difficult it is to create some kind of a bright line rule in this area, and why it's probably not a good idea to try. That there's so much going on out there already that you can't possibly know everything that happens, and you don't want to know everything that happens unless it becomes controversial. And it may be that you cannot deal with everything that is or possibly could be related to rail activity in a rule, and you certainly don't want to do it in this proceeding. I think you have to deal with the facts that you've got before you. In answer to your question about the activities that are going to happen at this site, you read off a list of things, and I've seen that list in the board's orders before, and I've seen it mainly in the filings by the parties opposed to the project, but it's not exactly the list of what's going to happen at the site. Let me just sort of cut through the words that have been misinterpreted, I think, in the past, and tell you exactly what's going to happen with respect to C&D waste and MSW, and as simply as I can. It's not complicated, and as Mr. Motes said, it's not a very sophisticated operation. With respect to C&D waste, a load comes in on the truck, a load gets dumped. The only sorting activity that goes on is going to be, as I mentioned earlier, to take large pieces of lumber or metal, set them aside temporarily, not send them off to sell or recycle or anything else, just set them aside temporarily right at the location. Then take the remaining chunks of material, run it through a shredder. And the shredder is not for the purpose of grinding things up into little pieces, into pebbles or dust or something that could be used as at a landfill or sold for as some other product. The shredder will reduce things to a reasonably uniform size, about 2 feet in length. That's the concept. A 2-foot piece of something is not a commercially saleable product, and that's not the intention of the shredding. The shredding is simply to prevent the phenomenon that I'm sure you can imagine, that if you put a large chunk of a flat object in a rail car and it goes in sort of crooked and it's leaning up against the side of the car, there's an empty space under it, and you can't fill that space with anything. Or if you put a large chunk of concrete in the rail car and you drop it from a height, it's going to put a big dent in the bottom of the car. So the shredding activity is just to reduce the size and the weight of the C&D waste to something that's manageable, that can be loaded efficiently, and that won't produce an unreasonable amount of damage to the rail car. And I believe Mr. Motes he didn't talk about shredding, but he expressed those same kinds of concerns about loading a rail car. The other purpose is to make sure